Attention farmers, tenants, landowners, and elevators. If you're one of thousands of Americans in the ag industry suffering from the decline in the corn market, then listen closely. The legal team of DeWald Deaver are here to share important information and help you recover your lost corn profits. Over the next 30 minutes, this educational program will highlight how Syngenta caused the corn market to collapse and cost American farmers billions of dollars in lost corn profits. The expert legal team of DeWald Deaver will reveal how Syngenta's actions and lies contributed to one of the largest collapses in the commodity market history. You will discover the issues and concerns surrounding this mass action lawsuit, how you can file a claim, and how you can join Cargill, ADM, and thousands of farmers across the nation in the lawsuit to help American farms get their lost profits back. If you're fed up with low prices and feel your bottom line has been affected, please stay tuned.
Hello and welcome to today's special report brought to you by $3corn.com. Now, if you're a farmer or know somebody in the farming industry, please keep the dial tuned right here because the information discussed is pertinent to your business. Below is the official website for DeWald Deaver, the law firm bringing you the information in today's special program. If you miss any of the information discussed or would just like to know more on this case, go to www.3corn.com. In 2013 and 2014, China placed a ban on all American corn. Now, the reason for this ban was because it contained a genetically modified trait that was illegal in China at the time. The reason it contained that trait was because of actions taken by Syngenta. Roughly 1/3 of all American corn is exported. Syngenta, however, marketed its Agrosure Viptera in a manner that the entire corn market became contaminated. This resulted in China's embargo of all American corn products. The resulting oversupply caused the corn market to drop dramatically. Every single farmer's price was impacted by Syngenta's actions, and the corn market has yet to recover to this very day, even though the embargo only lasted 1 year. If you planted corn in 2013, 2014, 2015, or 2016, you have been affected by this conduct. Syngenta knew its genetically modified traits weren't approved in China. Syngenta also knew that if it released that trait into the market without proper management, every single corn farmer would pay the price. Over the next half hour, we'll be sharing with you information, insights, and stories from the largest corn lawsuit in the country, and it's happening right now. It's not too late to get involved. You can still file your claim, but time is running out. Throughout this program, it's important to remember that everyone involved in corn production can file a claim in this lawsuit. Tenants, farmers, landowners, elevators, you have all been affected by this collapse, and you all have your own story to tell about how $3 corn has affected your business.
I'm managing the farm now on my own, and so I'm very cautious about what I'm doing because my husband has managed it for years. When we buy a product, we pay a great deal. But when I purchase that product, I do so with the confidence that the product is going to be something that will not damage my product that I'm producing. Really, we're trying to get more educated and everything out here. We don't stop our studies, but we don't know what's in those products that you're selling us. We take on the feeling that they won't be negligent in something. So, with all the added expenses, high-priced grain, created high-priced land, created high-priced taxes, put us up there to where we thought we were going to sail along, and then here came this product default that we were sold. And nobody wanted our export product. Our commodities dropped. They dropped from 7 to 3.5. They dropped half. Did the taxes come down? Did the fertilizer come down? Did anything else drop along with it? No. There's so many of us out here that were caught into this situation. We need someone to go to bat for us, represent us, and try to get us some compensation. A farmer has a mindset, and they don't like to get involved in things where they might have to be accountable and speak their voice, because that's one thing about the whole philosophy of a farmer. Our skills are centered on our farms. It takes quite a few skills out here to run a farm. And so when you come in behind us with a product, sell it to us that is not right for the farmer, and then it does bite us bad, we just kind of have a tendency to say, well, it's just like the hailstorm. That's kind of the way we feel about this corn situation. We kind of got hindsighted. Something got in on us we weren't aware of, and we've got to speak up enough to get some compensation to help us out. Yes, I know what's keeping you from getting involved. It's the fact that this large law firm has to have a little bit of your help. They have to have you to fill out some papers, to get some facts, some figures for them, to sign some forms, and this takes some of your time, so we just don't get it done. Come on, farmers. We could help a little bit here. Help us all a little bit. You must go home and do something on your own to help this whole litigation out. And that's the only way we're going to hold this product and the company that sold it to us responsible for cutting the corn price basically in half.
Hi, my name's Nate DeWald, and I'm one of the owners of DeWald Deaver Law Firm. The story you just heard is that of my grandma Doris. Doris counts on the farm for her retirement income, and much like you, she wants to leave a legacy for future generations. If you're anything like Doris, you're not making any money farming corn right now. The price of corn's come down, but the price of your inputs hasn't come down. Property taxes haven't come down. Most of my clients are farmers and ranchers just like you and just like Grandma. When I realized that there was a company who was greedy and irresponsible, who caused the destabilization of the corn market, I took it personally because it affected those I know and love. Look, you need relief. You need to recover your losses. That's why I've personally met with thousands of farmers at hundreds of town hall meetings across the Corn Belt. I can be your representative. I'm from the ag community, but we needed to partner up with a national firm to take on the likes of Syngenta. We decided to partner up with Watts Guerra out of San Antonio, and I want to share with you a couple of reasons why this partnership gives you the best shot at recovery. First, Frank Guerra of Watts Guerra in San Antonio, Texas, has been named lead counsel in Minnesota, where we have filed over 50,000 claims for corn farmers like you. Second, this is not a class action case. This is a mass tort case where there is an individual claim filed on behalf of every corn farmer. Third, there is no cost to signing up with us, win or lose. Like a crop share agreement, you will be paid the first 6 of every $10 we win for your farm. All of the costs of this action, which will be substantial, will be taken out of the lawyer's share of the fees, not yours. If you're a farmer, landlord, or even an elevator, you're likely eligible to file a claim in this matter. There's so much more information we want to share with you in this program, so stay tuned.
Bunge North America is a large grain shipper and handler in the Midwest. It has 66 elevators. When Syngenta launched its genetically modified trait, without the proper approval and without the proper process to get it done, folks like Bunge knew what would happen to the corn market. They foresaw that it would cause serious damage. So in 2011, Bunge actually stopped accepting Syngenta corn in its elevators. In response, Syngenta sued Bunge. They tried to make them change their practices to accept Viptera corn, but instead, a federal judge found for Bunge in every single count, and Syngenta lost that lawsuit. So a lot of farmers ask me whether this is a class action. It is not. It is what's called a mass action. Let me explain the difference. In a class action, you have a few farmer representatives that basically do the work for the entire class of all of the remaining farmers, but during the process, the class has very little control over what happens, whether the case is settled or not, or whether there's even a settlement that they accept. In a mass action, we have individual cases filed on behalf of over 50,000 farmers. During the process, the court will select what's called bellwether cases, which are called test cases. Some large farmers, some smaller farmers, some producers, some non-producers, to see what a jury thinks about the liability and the damages in this case. At the very end of the case, though, the biggest difference is in a mass action, which is what we have. Each individual farmer decides whether to accept a settlement from Syngenta or not accept a settlement from Syngenta. That is the biggest difference.
Hi, I'm Luke Deaver, and along with Nate DeWald, we own DeWald Deaver Law Firm, a small little law firm in Holdrege, Nebraska. Over the next couple of minutes, I'm going to take you through the timeline of events that have led up to this historic lawsuit being filed by thousands of farmers across the country. 2009, Syngenta releases the MR162 trait into the American corn supply and begins to market it as Agrosure Viptera. 2010, Syngenta announces that it intends to commercialize Agrosure Viptera corn, even though Syngenta itself did not plan on obtaining import approval for the corn trait from China until 2012. August 2011, Tom Dorr, president of the United States Grain Council, sent Syngenta a written memo that stated, quote, "The current situation regarding the commercialization of unapproved traits in China has raised industry-wide concern about potential near and long-term disruption to U.S. corn exports to China." Close quote. 2011, Syngenta sues Bunge Agribusiness. Bunge posted signs outside of their elevators declining to accept any corn that contained the Agrosure Viptera trait. Bunge elevators did not want to breach contracts by shipping non-approved corn. A federal court judge threw Syngenta's lawsuit out of court and again warned Syngenta in writing. Fall of 2011, ADM and Cargill also start to reject Agrosure Viptera at some of their terminals. On April 18, 2012, in a conference call with investors, Syngenta's CEO, Michael Mack, after feeling pressure from investors about the controversial decision to commercialize Agrosure Viptera, stated that Syngenta expected China to approve this trait, quote, "quite frankly within a matter of a couple of days," end quote. In fact, it took nearly 3 years until December of 2014 before Agrosure Viptera was approved by China. June of 2013, China first discovers Syngenta's Agrosure Viptera in its U.S. corn shipments, and China begins to destroy shipments containing this non-approved trait. In November of 2013, China places an embargo and bans all U.S. corn. April 2014, NGFA and the NAEGA issued a joint statement warning Syngenta that their actions would destabilize the corn market and cost the American farmer $1.9 billion in 2013 and $2.9 billion in 2014. In all, it's estimated that the American corn market fell more than $5 billion, which are the damages we are seeking in this lawsuit on behalf of the American corn farmer.
Corn prices are falling fast.
The price of corn.
The decline in corn prices.
Corn crop throughout the entire U.S.
Here in the U.S., corn and soybean prices are falling.
Many farmers in the heartland are on edge as corn prices continue to plummet.
I've never been to court before. The closest I've ever been to a courtroom was called up for jury duty one time. So I look at this as a last resort type thing. I honestly feel that there were damages here to the corn farmers, soybean farmers, agriculture in general. We were caught off guard just like everybody else. I mean, we heard about it through the news, ag news. Actually, it was a big enough deal. It was on national news and different things. And of course, we had no idea what it would do. We had done business with the Holdridge Law Office for years and felt that the guys, were very capable and did very good work. And when we found out they were getting involved with this, trying to help out the local area agriculture, we thought that was important, and we really support them in what they're doing. Don't know what we'll end up with, but that's no different than where we're at every year. We think it's worth our time and effort to apply and become part of the lawsuit. What comes of it, I don't know. If there is no settlement, it won't make or break our operation because that damage has already occurred. It could help us if we do get some settlement. I'm sure there's some elderly landowners that are on crop share that could really use the dollars. The people that want to put in the time and effort to see if there's some compensation will get the compensation if there is any. And those that don't want to put in the time and effort, don't think it's worth it, don't need the money, whatever their reason, doesn't matter. It's a fair way to do it, I think. And in today's environment with the low prices and our costs not coming down near as fast as the prices or income comes down, a few thousand here or there would really help. I'm sure that Syngenta thought that by the time the farmer bought the seed and planted it and harvested it and it would get exported, that they would have approval. And obviously it didn't go as according to plan, and of course once that was all in process, then it became too late. It wasn't our fault, and with this type of a lawsuit, the people that actually provide the information individually on how it affected them are the ones that have an opportunity to recover some of those losses.
Companies like Syngenta need to be held accountable for their actions. If you have been affected, have your voice heard today by filing a claim. By filing a claim, you're both ensuring the viability of your farm as well as making sure that you aren't affected by another company in the future.
And signing up couldn't be easier. Go to www.3dollarcorn.com, give us a call, or attend one of our town hall meetings. The important thing is that you get the information you need and file a claim before it's too late.
The law firm of DeWald Deaver are here to help you get your lost corn profits back. With their knowledge and expertise, you can ensure that you're in good hands. Signing up is easy and there is no risk or cost to you, but time is running out to file your claim. Don't let Syngenta's actions jeopardize your business. It's time to get involved. Join the thousands of ag workers across the country and help ensure that these mistakes never put your family and hard work at risk again. For more information or to sign up, go to www.3dollarcorn.com or call toll-free 1-844-344-CORN.
As in any legal battle, the right representation is key. Apart from winning your case, you want to make sure that you're compensated to the fullest extent and not left in the dark throughout the legal process or after. That's why DeWald Deaver's partnered with Watts Guerra, who's lead counsel on this case. They'll be filing your individual claims in Minnesota State Court. I'm joined now with John Givens, who's of counsel with Watts Guerra. Later on in the program, we'll have Frank Guerra here to answer some questions as well, but I just wanted to bring John on to clear up some questions you might have. So John, can you hear me?
I can hear you just fine.
Good. How are you doing today, John?
Doing fine.
Good. Well, I wanted to start off by explaining to you what we've been kind of talking about here and how Watts Guerra and DeWald Deaver, the partnership you two have together, is the best representation for the American farmer because it gives them that small town representation as well as a national law firm to handle that case.
Basically, what we figured out early on was that, and from our past experience with a lot of other mass cases like this where there are a lot of people with the same problem who we're trying to help, that it's very helpful to have a local firm who's familiar, sort of boots on the ground, if you will, with the issues, anything from weather to what's going on in the field, whether people are harvesting or whatever their activity is going on, and also have a law firm with the sort of national presence to be able to handle a case of this magnitude, that has the experience and the people to go out and pursue a claim, because frankly, against a big major corporation that's done something that's harmed a lot of people, like happened here with Syngenta, if just one farmer tried to do something on their own, they'd probably be ignored. But when you get a large group of individuals together who are trying to help and solve a common problem, there's strength in numbers and there's a lot better chance of doing it. And there's no better way of doing that, we think, than having a team of both a local law firm that can deal with folks and help them out if they have questions, as well as having a national firm that can actually go to court, take on these companies and help bring a resolution to a problem. And hopefully it's not simply about trying to recover money for folks that have lost money. It's also about trying to solve the problem so it doesn't happen again.
Yes, and some of the viewers at home may be familiar with you and your company from the rice case back a few years ago when you won $750 million for the rice farmers against Bear Crop Science, which is a case similar to this. How did that case maybe set a precedent or impact what you're working on for the corn farmers?
The legal precedent from those cases resulted in courts ruling that farmers have rights when some seed company mishandles, doesn't market properly, doesn't handle properly a genetically modified trait that they're growing or trying to market. If they don't handle that trait properly and it results in wrecking a market, causing farmers to lose money because the price of their commodity, whether it was rice or corn or milo or soybeans, whatever that commodity is, when that commodity goes down in value because of the careless conduct of a company in mishandling their genetic traits, the farmer has a right to recover for that. And so that's the importance of the rice case. And so basically, if the export market tanks, it's going to have an impact on the prices that folks get for their good.
So John, what you're saying here is they need to be held accountable, but how does that relate necessarily to this case against Syngenta and your goals as a law firm in trying to combat what they've done to the farmers? What is the goal, and how does that case relate to this case?
If a company doesn't engage in careful and safe practices, they frankly need to be called on the carpet about it. Personal responsibility is part of that. The farmers have their personal responsibility for how they handle their grain and how they live their lives. And seed companies like Syngenta need to take personal responsibility as well when they don't live up to the standards that our legal system imposes for protecting the marketplace and protecting the interests of the growers and the prices of our commodities. We all need to be good stewards.
So John, please tell me, what did Syngenta do that they need to be accountable for? I mean, did they know what they were doing was wrong?
Syngenta was warned in writing, in advance, that they were jeopardizing our export market to China for corn by having a trait that wasn't approved there in the marketplace. Before the 2014 planting season, the National Grain and Feed Association actually wrote a written report and advised Syngenta that if they went to market with their new trait Duracade, and if they continued to market their existing trait Viptera, MIR 162, it could cause anywhere from 1.2 to over $3 billion of losses. So before the planting season, they're told in writing they could potentially cause billions of dollars of losses to farmers, and yet they go ahead and launch a new trait that's not approved in over 40 countries. They continue to market the one trait while an active ban of U.S. corn is going on from China.
So John, tell me, how does one get involved with this case, and is there a cost to it? How does your law firm, charge or compensate for lawyers getting involved in an action like this? Tell us what you guys have.
If at the end of the day we are unsuccessful, if our belief that the case has merit is wrong, the client is not going to have to repay us those expenses. And so that's one of those things that if you're interested, you may want to research and because, like I said, there are a number of different fee agreements I've seen. If you go to our website and look at the fee agreement that's on $3corn.com, you'll be able to log on there, pull up a copy of the fee agreement. If you don't have it, you can call Nate or Luke, and they can explain it with you on the phone or mail you a copy of a fee agreement. But you'll see some language that's bold in that fee agreement, and you'll be able to see exactly language that we say we're paying the expenses, and if we're unsuccessful, you owe us nothing.
Thank you, John, very much for all those answers to those very, very common questions that a lot of you may have had. We're joined now with Frank Guerra of Watts Guerra, and he is here to answer a few questions as well. Frank, can you start out by just telling us a little bit about how this lawsuit got started and who did file the first claim?
The first claim against Syngenta for the disruption of the corn market was filed by Archer Daniels Midland, then Transcoastal Supply, and finally Cargill. Now over 50,000 farmers have filed individual claims against Syngenta for the disruption of the corn market.
Frank, is this a lawsuit that is just for corn farmers, or can you explain a little bit about who can file a claim in this lawsuit?
We represent over 50,000 individual farmers and elevators who have made claims against Syngenta for the disruption of the market as a result of its conduct. If you grew corn or soybean or milo in 2013, 2014, 2015, or 2016, you have suffered losses as a result of Syngenta's conduct.
What about the actual trait itself? If you didn't plant, Syngenta's Agrosherviptera trait, are you still covered?
Although the collapse of the corn market was directly caused by Syngenta's GMO product, you do not need to have grown Viptera or Duracade to be a plaintiff in this lawsuit. Every single farmer, regardless of what you grew, was affected by Syngenta's actions.
So what exactly is your firm's role in this case, Frank, and explain to them what you're doing to represent them across the country?
The court in this case has appointed a team of lawyers that manages the entire litigation against Syngenta. We are responsible for arguing motions in front of the court, taking depositions, hiring experts, managing the litigation, and eventually trying this lawsuit against Syngenta.
Thank you, Frank. Any final thoughts or words of wisdom for farmers who still may be unsure about this process?
If you're a corn farmer, our firm would be honored to represent you. Join over the 50,000 farmers in this litigation against Syngenta.
Thank you, Frank, and thank you to John for joining me here today and answering some of those hot button questions that I know a lot of you farmers at home have. Well, that's all the time we have for today, but I want to thank you for joining us. I hope you got all the information you needed concerning this case, but if you didn't and would like to know more, just go to the website or the toll-free number below, and they will get more information to you as soon as possible. Everyone in the corn industry has been affected by this case. Now's your chance to join the fight against Syngenta and recover your lost corn profits. Thanks again for joining us.